agreements. Additionally, honourable members, all agreements must be tabled in both the National Assembly and National Council of Provinces for information purposes. Honourable members, I wish to conclude my introduction by citing the 1997 book entitled Casino Capitalism by Susan Strain, where she wrote that states frequently oppose granting authority to international institutions, and she held the view that government often resists attempts aimed at devolution and delegation of powers and functions to international organizations. South Africa, of course, honourable members, unequivocally believe in the creation of a just, humane and equitable world and in a rules-based international system of global governance based on international law. We would therefore always have the ambition to continue to conclude international treaties and agree to multilateral outcomes as part of our commitment to collective action to address global challenges. Honourable Chairperson, with your express permission, Mr. Lahir, who currently acts as the Acting Chief State Law Advisor, will now proceed to deliver the presentation on the detailed role of Parliament in the treaty making and in the implementation of South Africa's international obligations. Thank you very much, Lano.
Good morning, Honourable Chairperson, Honourable members.
I was wondering what's happening to you now. You're welcome.
Thank you very much, Honourable Chairperson. I just wanted to say I've been asked to convey Mr. Lahir's apologies for not being able to present. He's unfortunately attending Cabinet with the Minister at the moment, so he's asked me to present in his absence. So perhaps I'll just get started if we could move to the next slide. So to start off with, I think the first question would be, what is an international agreement? And Section 231 of the Constitution refers to international agreements, but it has the same meaning as the term treaty. And for definition of the treaty, we turn to international law. We look to Article 1 of the Vienna Convention on the Law of Treaties, which defines the term as an international agreement which is concluded between states, and it has to be in writing, and it is governed by international law. It can be contained in either one or more instruments, and it doesn't really matter what the designation of the instrument is. So from this definition, what we can garner is that the essence is who can conclude a treaty and what its content is, rather than the actual title of the instrument. International agreements or treaties are concluded between subjects of international law that have international legal personality. So this would be either states or intergovernmental organizations that have been granted international legal personality. We can move to the next slide, please. So in terms of the necessity of treaties, treaties are important in the international sphere as they form an indispensable part of the architecture of international relations. They serve as a tool through which international relations are given substance and by which obligations are created between the parties thereto. In terms of the International Court of Justice's statute, treaties are regarded as a source of international law. States also use treaties to establish legally binding obligations between them, but it can also be used as a way to express their cooperation with one another. So all in all, treaties are the basis for an international rules-based system. Next slide, please. For South Africa, the importance of treaties can be seen in the way that they are used to promote the country's foreign policy objectives. Apologies. They may also be used to pursue national interests, and ensure that national values are reflected in the texts of treaties. It's through active participation that within the governing structures of these multilateral treaties that the country can also gain influence in the implementation and management of treaties. So, for example, where a treaty creates various organs or bodies, when South Africa is able to really actively participate, it has a position and an opportunity to influence the direction of the way in which the treaty is either implemented or for governance purposes. Next slide, please. The implications of treaties is that once treaties are entered into, which is done through the basis of consensus by states that have treaty-making powers, and a conclusion of a treaty by a state is therefore an act that it performs on the basis of its statehood as well as its sovereignty. Once states have concluded treaties, they're legally obliged to give effect to those obligations in the treaties. So in that sense, it implies a limitation of their freedom of action within the international sphere. So although a state may voluntarily agree to limit its rights in a specific area, in doing so, it is also in and of itself carrying out a sovereign act. States must be able to give effect to the international obligations contained in the treaty. Next slide, please. The authority to conclude treaties is also found in Article 6 or in the Vienna Convention Law of Treaties, and Article 6 provides that states have the capacity to conclude treaties. This was subsequently extended as international organizations entered the realm of international negotiations and basically the sort of broader community of states. This authority was also extended to international organizations, which is contained in a separate convention, but also addresses the conclusion of treaties between states and international organizations as well. Article 7 of the Vienna Convention on the Law of Treaties provides that heads of state and government, ministers of foreign affairs have the authority to conclude international agreements, and they're able to do so without presenting an instrument of full power. An instrument of full power is essentially a document that gives authorization to a particular person to conclude through signature a treaty. And so heads of state and government and ministers of foreign affairs do not need this particular document on the international plane to show that they have the authority to sign a treaty. International practice shows that states act in the international arena through their executive arms of government as the institution itself that represents the state. And then ultimately a state's constitutional arrangements will determine the role of parliament within the conclusion of treaties. Next slide, please. For South Africa, regarding the authority to conclude treaties, we turn to Section 231 of the Constitution. And in terms of the Constitution, it's only members of the national executive that have the authority to sign treaties. This can be found in Section 231, subsection 1 of the Constitution. And the President's minute is the means through which this authority is given on a domestic level. It must be countersigned by the President as well as the relevant line function minister. For agreements falling within the ambit of Section 2313 of the Constitution, these treaties must be tabled in Parliament for information purposes. Whilst those concluded under Section 2312, they would require authorization from Parliament. It's important to note that if the requisite approval is not obtained from Parliament in a Section 2312 agreement, South Africa cannot register its consent to be bound by the treaty. This is done through an instrument of ratification or accession. And if constitutional law requirements have not been adhered to, it can also have serious legal implications for the line function department who has not complied with that process. Next slide, please. So for the role of Parliament, in many states, Parliament does not have a specific treaty-making role, and it's actually an exclusive executive prerogative. Some constitutions do assign an oversight role to Parliament, and that is the case with South Africa. So as provided for in Section 231 of the Constitution, Parliament is given this role in treaty-making within the country. So Section 2312 provides for the approval of certain treaties in Parliament, and Section 2313 requires that treaties must be tabled in Parliament for information. The purpose of this is to ensure that South Africa's treaty regime is open and transparent as well. So in the same way, South Africa's foreign policy process is an open and transparent one that is often interrogated in Parliament. It's covered by the media, civil society, and that ensures that South Africa pursues its foreign policy in a manner that is responsive to the popular wishes of the country. Next slide, please. So for South Africa's treaty-making practice, a lot rests on line function departments. They are responsible for determining whether South Africa should be concluding a treaty, and this is informed by government priorities. These line function departments would identify cooperation opportunities or advantages that other states may offer to meet domestic needs, for example, in the context of health or education, science, technology. And they will then enter into negotiations, which on occasion can become very protracted and can take a number of years before they are finalized. South African positions are developed by these line function departments that are responsible for the relevant subject matter of the international agreement that they are negotiating. But consultations must take place, particularly within the context of government. So I think it was 2019, the Foreign Service Act was signed by the President, and it entered into operation in 2022. And this act provides that DIRCO is responsible for the implementation of foreign policy. And so it's very important that line function departments consult with DIRCO in order to ensure that our national interests and the way in which we put them forward are aligned with our foreign policy. In some instances, Cabinet approval is obtained for positions to be taken at multilateral negotiations, but it's not always the case. It would be dependent on the particular subject matter and the level of necessity to obtain Cabinet approval. Guidelines for the participation of government in the context of multilateral negotiations was also approved by Cabinet, and it provides a guiding light for how to engage in multilateral negotiations. Next slide, please. So Section 2312 agreements, those are the most important ones for Parliament because it requires their approval before South Africa can bind itself to a treaty on the international sort of realm. So Section 2312 of the Constitution requires either ratification or accession, and this is normally the case in multilateral agreements. They would have financial implications, which would require additional budgetary allocation from Parliament, so not that which falls within the budget already allocated to a particular national department. And they would have legislative or domestic implications. So ultimately, it may require that our legislation needs to be amended or adapted or bolstered in some respect. In some instances, we may not have legislation at all, and so it would require new legislation in order to allow us to become a party to the treaty. And in this instance, both executive and parliamentary approval would be needed before South Africa can be bound on the international sphere. Next slide, please. So the procedure for concluding Section 2312 agreements is that such agreements do require parliamentary approval and must be submitted to Cabinet for discussion. Once it's then gone to Cabinet, Cabinet would make a recommendation to Parliament regarding the accession or the ratification of the agreement. Cabinet would propose that reservations perhaps be made if this is allowed within the agreement itself. And in order to obtain approval of Parliament to ratify or exceed an agreement, it must be tabled in Parliament. Letters requesting tabling should be addressed to the Speaker of the National Assembly and the Chairperson of the National Council of Provinces. And then the prescribed procedures must be followed. For example, guidance must be sought from the parliamentary officer in order to ensure that the processing is done in the correct manner. Next slide, please. So, excuse me, in relation to reservations, Based on the legal advice received from the state law advisors at the Department of Justice and Constitutional Development and Department of International Relations and Cooperation, it may be that line function departments would be suggested to enter reservations, and this would then be proposed to Cabinet. When Parliament is requested to approve ratification or accession, and there is a recommendation for a reservation to be entered, this should be noted. In some instances, Parliament may suggest an interpretive declaration. This is slightly different to a reservation, where a reservation would have legal implications. An interpretive declaration is rather an explanation of how a particular provision is understood from that country's perspective, rather than changing its legal implications. Parliament may refer treaties back for formulation of declarations or reservations if it considers that would be appropriate in the circumstances. Next slide, please. The relevant portfolio committee at both the National Assembly and the Select Committee of the National Council of Provinces would need to consider the agreement. The reports of the committee are then are considered by the National Assembly and the National Council of Provinces when they sit separately. The adoption of the reports by both houses indicates the approval by Parliament. And these decisions are then recorded in the minutes of the proceedings for both houses. From a practical perspective, it is very important that we also receive a clear indication in the minutes where Parliament has determined that there should be a reservation put in place in the context for an agreement. So it is necessary that where this is a recommendation, it is also discussed in the context of Parliament. Next slide, please. For instruments of accession or ratification, after approval by Parliament, an instrument of ratification or accession is prepared by the line function department in consultation with the treaty section within DIRCO. A copy of the minutes of both houses reflecting the decision of the houses must be submitted to DIRCO with the request that the Minister of International Relations and Cooperation should sign the instrument. The instrument must also be bound before submitting it for signature to the Minister of DIRCO. And then the instrument is deposited by the relevant line function desk of DIRCO with the depository as prescribed by the agreement. So often the agreement will say who, whether it's a country or an organization, serves as the depository, and that is the entity to which this instrument would be submitted. The date of proof of depositing must be communicated to the treaty section for record-keeping purposes. Next slide, please. So in relation to the process for Section 231, subsection 3 agreements, these, as I've indicated, are only tabled for information purposes. So in terms of Section 2313 of the Constitution, these are agreements that are of a technical, administrative, or executive nature. So the way in which the Department of Justice and DIRCO has interpreted this over the years is that these are agreements that do not require ratification or accession. They would not have extra budgetary financial implications, and they would not require legislative amendments. So Section 2313 provides that agreements that do not require approval of the National Assembly or the Council of Provinces must be tabled within a reasonable time. So in 2017, there was a court case called EarthLife, we term it the EarthLife Africa case. And essentially, a number of factors were discussed in this case, but an important one for us in terms of our processes was the question of tabling within a reasonable time. And it was noted that some agreements had taken several years before they were tabled before Parliament, in excess of some cases 20 years. And the court found that this was then not a reasonable time. It was unconstitutional. And so these treaties had to be renegotiated and signed once again. So this resulted in our office changing our policy to make sure that we wouldn't have a similar situation, that we now have a process that where you deal with a Section 2313 agreement, it would not necessarily enter force directly upon signature. Rather, the parties would sign, and then after it's been tabled in Parliament, they would then exchange notifications to say that they've complied with their constitutional obligations, and this treaty can now enter into force. That way, we ensure that Parliament has had an opportunity to review the text and only then would it become binding on South Africa. The purpose of tabling is obviously for information purposes only, and it does not require approval, but it is important that Parliament has sight of what these treaties provide. There's also no specific time that's allocated to what constitutes a reasonable time, but we think that more than a year shouldn't really be considered to be reasonable. It would be ideally less than a year after signature that a treaty would be tabled. Next slide, please. So the procedure for concluding Section 2313 agreements is that approval by the executive is needed. In this regard, as I'd mentioned, the president and the responsible line function minister would sign a president's minutes, giving authorization to a particular minister or any member of the national executive to sign. Sorry. A Section 2313 agreement would bind the Republic without approval from the National Assembly and the National Council of Provinces, but as I mentioned, it must be tabled within both houses within a reasonable time. Tabling is the responsibility of the line function department, so they must ensure that once they have gone through the process of signing, they also follow the process for tabling. And letters requesting tabling should be addressed to the Speaker of the National Assembly and the Chairperson of the National Council of Provinces. Next slide, please. So not all international agreements require legislation to become binding on South Africa. It's only those that affect the rights of South Africans that have budgetary implications or have a regulatory effect that need to be implemented as part of a multilateral framework and included within South Africa's domestic legislation. So your general cooperation agreements that you'll find, we regularly, those are amongst the most prominent ones that we sign. For example, general cooperation on health or science and technology, those do not need to be incorporated in domestic legislation. But when you're dealing with multilateral agreements, for example, human rights conventions like the International Covenant on Civil and Political Rights, those types of international agreements would likely need to be incorporated into domestic legislation. Next slide, please. Thanks. South Africa's treaty section is also the official custodian of the South African Treaty Collection. So it is the only official record keeper of bilateral and multilateral treaties that South Africa is party to. So we keep all of the originally signed agreements in a fireproof safe at DIRCO. The treaty section also provides information services on all aspects concerning treaties. So, for example, the dates of signature, ratification, accession, entry into force, all those details in relation to agreements that South Africa has become a party to. The treaty section also serves as the custodian of a database on provincial and local government arrangements and twinning agreements. And it carries out the registration of agreements with the United Nations, which is required by the United Nations Charter. And it does the physical binding of all agreements and instruments of ratification and accession before signature. I should probably just mention also that the treaty section is entirely dependent on line function departments, provinces, and others to submit those documents to it once these are signed. And it is therefore critical that all treaties must be deposited by the line function departments to the treaty section for appropriate and adequate record-keeping purposes. Next slide, please. The last aspect is the monitoring of treaties. The Forum of South African Directors General Management Committee instructed DIRCO in 2012 to conduct an audit on outstanding country reports and agreements for which constitutional processes have not yet been completed. The purpose of this was to create a measure to improve South Africa's compliance with its international treaty obligations. So Cabinet should be provided with 2 reports twice per year, one that relates to the report on national reports to treaty bodies under multilateral agreements, so where Part of the obligations that South Africa has undertaken is to do regular reporting on the status of the implementation of the multilateral agreement, and then reports on multilateral agreements that have been signed, but where we have not yet finalized the constitutional procedures for entry into force. So that it hasn't gone through parliamentary approval before we've been able to finalize the instruments of ratification or accession. And then departments are regularly requested to provide their inputs on the progress of these two particular reports. And ultimately, DIRCO remains the custodian of all agreements, but the monitoring and implementation, that remains the responsibility of each line function department, as they are the ones that are practically implementing those international agreements. And with that, I've come to the conclusion of my presentation, and thank you very much for your attention.
Honorable Chair, thank you very much from our side of DIRCO. Thank you.
Nothing to amplify.
To show the yesterday, but when you able to what man? Let me check. We are struggling today. I'm trying to help with the chairperson. They only captured 3 people. So phone A, the phone on people.
Can you try to get reports that are sitting with reports? Mobile.
This is one of them.
Can you hear me?
I have muted Honorable Flow.
Yes, so at least you could come to a rescue. Yeah. Honorable members, we can have hands now. And I will leave the taking of the hands to Honorable Kumbatra, who hails from the Eastern Cape. Over to you, Honorable Kumbatra. You can take over now.
Oh, thank you. Thank you very much. I just got cut a bit. I just wanted to check, are you taking hands?
Yes. On Sfad no the hand. Stati Sanda, Razama, we are taking hands.
Okay, no, it's fine, Chair. Sorry, I just had a bit of some network issues there. But firstly, I would like to greet all of the honorable members in the session, and also the DM present and the team from Durban from Parliament. Chair, firstly, mine is to welcome the presentation which have been presented, which was presented this morning, and also and formally acknowledge it. Chair, I think firstly, I think it's very important. I see that Parliament does not have a clear role when it comes to these treaties, and I think it's very important to have Parliament involved in these processes because these treaties do, in essence, do have an effect and direct implications to the lives and well-being of our people, through trade relations, security, and obviously also protecting our sovereignty. So I think from my view, I think it's very important that there is a way as this committee, we need to find a way as this committee to review and strengthen this process, this treaty process, and see how, as Parliament, how we can use it to enhance even our people-centered oversight approach. So that was that from my side, Chair. I think it's very important that Parliament and also this portfolio committee plays a very critical role when it comes to these treaties, and it's not a by the way factor as presented. Thank you, Chair.
Honorable Kumbatra. It looks like something has happened to Honorable Kumbatra. Okay, we have the hand here of Honorable Wesley Stay to the left. Douglas.
Good morning, Mr. Chair. Can you hear me? Dankie. Bye, dankie. Let me start by saying thank you to Deputy Minister Botes and the team from DIRCO. And I want to greet you all in the language of the First Nation people, the Khoi and the San. Kaites, good day. Mr. Chair, one of the problems that we have is that treaties have not resulted in our people escaping poverty for the last 30 years. There is something wrong that has to be changed in the fundamental way treaties are designed, oversought, and actually implemented. Because right now, treaties haven't taken our people out of the shacks, it hasn't taken our people out of poverty, it hasn't benefited our minerals at source. What it's done is entrenched apartheid era colonial power over the economy and over our future. So, Mr. Chair, I think the colonial system that has been implemented in DIRCO needs to be completely overhauled. We need to have a complete overhaul of how our treaties are done and how our treaties are signed and the impact of it on the ground. The presentation is very helpful in explaining the process, but I think the real issue is not whether a process exists and how it's happened. It's whether that process gives Parliament meaningful power, or whether we are simply confirming decisions that are already taken elsewhere by the executive. You see, for me, the biggest challenge is how we sign these treaties and whether Parliament has a real role in it, because we are the representatives of the people in South Africa. We are elected to represent the interests of the people, and these treaties and these agreements get signed that lock us into things for future generations that may not be in our best interest as the poor in South Africa, as the colored, as the black, as the Khoi and the San, and as the even progressive white people. We are not benefiting from these treaties. There's 30 years of treaties, and our people still live in poverty, Mr. Chair, and we don't own the economy, and we don't participate in the economy that comes from the land. So we must be defenders of our own sovereignty in these treaties, and we must have accountability and be people-centered in our international relations, Mr. Chair. And I love the fact that we did the people-centered outreaches last year, but how does that process actually, from the grassroots, what people want to see, jobs provided, outcomes-based, not just activities and treaties that are signed with these nice cocktail functions, but it doesn't actually make a difference towards the people. So if we look at the legal framework that was outlined by our colleagues from DIRCO, especially under the Constitution and Section 231, it governs really how the treaty-making process is used, but it also gives us a lot of opportunity for this to be used and to be able to go around things. We see in 231.1 that the executive negotiates and signs treaties, and 231.2 that Parliament must approve binding treaties, please. And this is very interesting for me. I'd like to ask, and one of my questions is, can we be provided with the treaties that have been signed since July 2024 by the GNU? I'd like us to see that, and I'd like it in writing, Mr. Chair, not just a response via written or not just via verbal response, but I'd like to see what exactly things have been put under the technical administrative agreements where no approval is required and it only needs to be tabled. So these are things that I'd like to see, because these things are basically impacting our lives. And it's going to impact our lives, not just for this term with the GNU, but also if it's a 5 or 10 year period and it's longer, we need to know what we are going to inherit in the future, Mr. Chair. So can the department explain to us how it ensures that Section 231.3 agreements are not abused to bypass full parliamentary scrutiny? And how many international agreements in the past 5 years were classified as technical and therefore not subjected to parliamentary approval, and why? Because we want to know why it was not. I want to know what the technical difference is between those that are presented to us that we have to approve as representatives of the people and those that the executive can just sign on their own. I'd like to know, because we don't trust this executive and what they have been doing. Because the proof is in the pudding, and pudding is sour here in South Africa. What criteria determines whether an agreement is technical versus binding, Mr. Chair? And that's what I want to find out. It is clear that South Africa has a structured treaty-making process, and it's grounded in the Constitution, but the Constitution can also be changed because it's not serving our people. And so, yes, while we use the Constitution as a basis for our discussions because we are law-abiding citizens, we must have proactive measures and think of the future and think that, man, this thing is not working for us. It hasn't worked for us for 30 years. Maybe we should change it and make sure that Parliament has a proper scrutiny over the outcomes of this. So the advisory paper correctly states that the treaties are meant to advance national interests and support development, but can the department quantify this for us? How many treaties have directly resulted in job creation, investment flows, or measurable benefits to local economies and to local communities? This is the kind of thing that, we're always talking about economic diplomacy. Economic diplomacy is born and it's made concrete through treaties and bilateral and multilateral agreements. So if we, as the people's representatives, don't have sight of it, don't even have input over it, we are just going to be rubber stamps. And that's what we are right now. We're just rubber stamps for whatever this executive decides to do, with no scrutiny, with no oversight, and with no responsibility to us as the people, because we represent the people as much as this GNU represents the people. We often hear about negotiations, ratifications, and international participation, but how does the department track the execution on the ground? What percentage of treaty commitments are fully implemented with South Africa? Because we know, I've been part of those delegations that have gone overseas. I've seen a lot of these bilaterals and treaties. Even in our last visit to Durka office, I asked about it and I saw some of it. They took me into that vault that's fireproof. And the reality is, Mr. Chair, most of those things are sitting there, and not any of it has been used, as far as I can see, to take our people out of poverty. That if Durka is not serving that purpose of helping us be a better country and to help our people out of poverty, then what good is it in its current form? So, Mr. Chair, we need to make sure that we're looking at employment, local industry development, access to markets, and we want to see those treaties, and especially since GNU took over, but let's look at the last 5 years. How has things changed and what has been done to implement those things? And who are the beneficiaries of those treaties? Because that's the other thing. I've been to a lot of these meetings overseas, whether it's in China, Russia, America, the EU. I've been to these big business meetings with the delegations at the embassies. And the reality is it's still the same suspects, still the same people that are benefiting from apartheid and colonial era, who own the land, who own the mines, who own everything. They own the JSE, and yet they are crying victim to people like Donald Trump and saying that there's white genocide. It's absolute nonsense. And we need to address these things because these things have consequences, Mr. Chair. How does government determine, at what point Parliament must become meaningfully involved? I'd like to know the thinking of Durka regarding that before negotiations begin, or only after agreements are already signed and we must just rubber stamp that. Because if it's the latter, then our role becomes reactive rather than decisive. So I need to know, where does that decision get made to say, okay, we must take this to Parliament, or no, this must go, this we can just do under 231.3. So, Mr. Chair, so these are some of the really important things that we need to look at. And, we need to, as MK, we really believe treaty making must move from a focus on activities to a focus of outcomes. Each treaty must have clear economic targets, clear job creation benchmarks, measurable benefits for communities. We should introduce a national treaty performance dashboard, tracking number of treaties, implementation status, economic impact, jobs created, so Parliament and the public can see tangible results, Mr. Chair. And then Parliament must be involved before negotiations begin, not just after the signature. We would require a formal parliamentary mandate for major treaties so that the people can see what we're getting ourselves into, and that politicians who have unscrupulous desires don't get left to their own devices and sign away our future forever, Mr. Chair. No treaty should be signed without a full economic impact assessment or a risk analysis or benefit analysis for local industries. These are basic things that we don't see in our treaty and in our discussions, and we need to put that in place. We must ensure also, Mr. Chair, that traditional leaders and indigenous communities must benefit from these treaties. Right now, there's no mention of the traditional leaders, kings, rulers of the Khoi, of the San, of the Xhosa, of the Zulu, of any of our people and landowners as such. They're not involved with any of these treaties, and yet they are the most important people because they're the Aboriginal indigenous owners of this land, Mr. Chair, and they should have a say about what happens to the future of this land, not sold out by people who only have money in their brain. There must be consequences for non-implementation, both within government and across departments responsible for the execution of these treaties, because all treaties must be tested against a sovereignty framework to ensure that we do not undermine our land reform process, that all development must be state-led, and we must be economically independent. We can't be signing treaties that make us economically dependent and on an extractive economy where we send raw materials out and all we get for that is more taxes and more tariffs and more things that keep us down. Chairperson, I think while we speak about these treaties and these processes, we must also speak about power and a deliberate misrepresentation of South Africa on the global stage. There's a coordinated narrative being pushed internationally that paints our country as unstable, unsafe, and incapable of governing itself. That narrative is not innocent. It is political, it is strategic, and it is dangerous. That is why President Trump continues to falsely claim white genocide against white farmers as a pretext for military or colonial intervention in our country. This false narrative is being driven not only by foreign interests, but by local people like the Democratic Alliance and AfriForum, and those people were in the Oval Office last year who export a distorted version of South Africa to the world. This has consequences for our treaties. This has consequences for AGOA. This has consequences for us to become a victim of another illegal invasion like Iran has been, like Gaza has been, like Venezuela has been, like Cuba is. They're going to try the same thing with us. We can see the narrative is already building up for that, Mr. Chair. And we need to make sure that we are people of peace, that we remain actively non-aligned, but that we stand sovereignly, Mr. Chair, and that we don't allow people to paint us in the wrong light. So we believe in diplomacy, and we must make sure that the diplomacy and treaties, Mr. Chairperson, are not neutral documents. They are instruments of power, and the real question is before us today is, are we using treaties to defend South Africa's sovereignty and advance our people, or are we signing away our future under pressure from a global system that doesn't serve us? We must make sure, Mr. Chair, that our people are protected, our future are protected, and that these treaties actually serve the needs of the poor. Thank you, Mr. Chair.
Thank you very much, Honorable Douglas. The chair has lost his connection, and I did request that I take over. I'll then move to Reverend Honorable Mishwe.
Thank you, Acting Chairperson. Greetings to all members and the department officials. I want to link up my questions to what Honorable Douglas raised. Section 231, I think, is very problematic to me, particularly 22313, because it speaks about treaties that bind the Republic without the approval of Parliament. This is very problematic and unacceptable to me and to us, because Parliament is in touch with the people on the ground, and Parliament is between government and the people. And so if the people are going to be bound by something that did not have an input in, something that they do not agree with, or that did not have a side of or contributed in its drafting, they are just told that this treaty has been signed, you are obligated to do likewise, because according to Section 2313, Parliament does not have to approve what the cabinet or that minister and fellow ministers who are part of driving the treaty have decided. So I want to know if there is a convincing reason why Parliament should not be part of approving a treaty, and why the government can form treaties without the approval of Parliament. This is very dangerous, because we would have things imposed upon us that we would never have agreed with. And secondly, South Africa has a policy also of involving the public in public participation processes. Now, if we talk about being people-centered, the people must have a voice. So I want to know, in the context of this 2313, when will there be a time or an opportunity given for public participation? Who should decide? If, for example, this committee looks at the seriousness of what is before them and they say they think people have to be consulted, who should approve this? Or can cabinet say no, there should be no public participation process in this matter, or who would say yes or no in that matter, in such matters, because the public are used to participating when it comes to serious issues that will affect them and their lives and the generations to come. But not to be told that there will be some treaties that will be ratified without the approval of members of parliament, while at the same time we are told that cabinet government is accountable to parliament. I mean, this is a contradiction. It's like parliament is now being undermined because you are told cabinet and government is accountable to parliament. Parliament must hold government accountable, and yet government is allowed to approve things with these treaties without their approval. This is definitely creating confusion. And maybe thirdly, the tabling of information of treaties for information purposes only needs to be clarified. Why table it in parliament if it's just for information purposes? Because we can just be told, go to such and such a place and you will get information on this particular treaty. When this is tabled in parliament, this treaty, if it's for purposes only, it means there will not be a debate in parliament about it. Or will there be a debate? And if there would be a debate, what will be the purpose of the debate? Because we are told some treaties will be tabled for information purposes. And if we see that information that is tabled and we don't agree with it, are we toothless, or don't we have what will be our remedy? How would we have to respond when we are given information that we don't agree with, because we are told that it is for information purposes only? And then my last question would be also touching on what the last speaker asked. Is at what stage should Parliament be involved? At the early stage when the treaty is being drafted or designed, or after it has been ratified by the relevant powers, and then it just comes to us to be rubber stamped? At what stage should Parliament be involved? The beginning, the end, or in between, before the treaties have been signed? At what stage is what I want to know. Will Parliament be involved? Thank you, Acting Chair.
Thank you, Reverend Mashwe, for your input. Honorable Moela.
Thank you very much, Chairperson, and thank you very much for the presentation, and greetings to DM Portes and all members of the Follow Committee, and also the DERCO staff and all the South Africans that are following these proceedings on the social network. I've got few questions of oversight with regard to the presentation. The first one is, how does the department ensure that treaties under Section 231, subsection 2, advance South Africa's developmental objectives, economic transformation, and national interest while protecting sovereignty and fiscal space? The second one is, what mechanism exists to guarantee meaningful stakeholder consultations, including with provinces, labor, business, and civil society before finalizing negotiating positions? For agreements requiring approval, what reservations or interpretative declarations are processed, and should Parliament recommend additional ones to safeguard policy space? The last one will be what steps are being taken to prevent delays in tabling Section 231 subsection 3 of the agreement within a reasonable time in line with constitutional and judicial expectation? Thank you very much, Chairperson. That is my question for clarity. Thank you.
Thank you very much, Honorable Muela. And then we can move then to our last speaker, Honorable Smith.
Thank you very much, Chair. And I just want to thank the presenter for a very insightful presentation. I think it had some very, very interesting aspects, certainly for the committee. I think I'm largely covered by many of the other members as to the role of this particular committee in treaty ratification in South Africa. I think it's one of many examples that just puts on display the extent to which this committee is in effect a tick box exercise as it relates to the formation of South Africa's foreign policy, the appointments of ambassadors, etc., etc. And it does seem as if there isn't much input actually from the committee insofar as treaty making is concerned, and I think that is a concern that has been raised across the board. But you know, it seems as if that is by design in terms of the existing legislation and the constitution, where most if not all power, executive power, certainly over foreign affairs, rests within the presidency and the Minister of DIRCO. So I think it points out again some of the very centralized means in which foreign policy is legislated in South Africa, and the changes I think that are necessary there to make it more inclusive, certainly from a parliamentary perspective, and more transparent, I think, in the interests of public accountability. I think if you can compare, for example, treaty making and ambassadorial appointments to other nations around the world, they are far more consultative from a parliamentary perspective. There are committees that are set up to interview ambassador nominees, for example, and to look at clauses in treaties before they are included or amended as part of a national endeavor by the executive. And I think that South Africa really needs to look at replicating some of those systems for greater accountability as well. Even just back here in Parliament, if you look, for example, at the role and responsibilities of the Judicial Services Commission, there should be some sort of similar mechanism actually within the DIRCO Portfolio Committee insofar as treaty making and other sort of foreign policy appointments are concerned. So I think that point has been made quite clearly. The second query that I have is around, I suppose, the sort of role of treaties at the moment is facing a bit of an existential crisis because they do legislate the multilateral world that many countries exist in and are guided by. And I think having looked most recently at the role of multilateralism and multilateral institutions, they are increasingly being seen as toothless organizations without much effect, despite making lofty promises and setting very ambitious goals to reform global governance and promote peace, for example, but legislatively are very ineffective and have no means of actually being legally binding or enforcing sanction. So my question, I think, pertains to means in which South Africa can maybe play a more pertinent role in setting a good example for a start in terms of our obligations to the treaties that we've signed. I think the Rome Statute is a very good example where we have been obligated to arrest heads of state who've passed through our country, Omar al-Bashir being the most recent, and have not acted on those. So, you know, these treaties seem again to be nice to haves, and they make a country seem as if it's committing to a certain set of principles. But when it comes down to the wire, there isn't actually much implementation. So I would be interested to hear the presenter's thoughts on how treaties could be more legally binding or place greater legal obligation on member states, such as South Africa, to actually uphold the rule of international law more consistently. And then my final question, Chair, actually relates to paradiplomacy and subnational government level in terms of treaty making, because I think that South Africa's political reality still needs our legislative components to really catch up. And I speak about the coalition future of South Africa, which was the inevitable outcome of our political system. But we see that when it comes to treaty making, maybe not as formally as at national government level, but at local level, for example, if you look at twinning agreements, if you look at trade deals between provincial governments and other regional governments in other countries, South Africa doesn't necessarily have a very detailed legal framework to give guidance to those sorts of agreements and treaties that are, or less treaties, I suppose, but agreements that are signed between subnational governments. And my question is, to what extent is DIRCO actually engaging with, for example, the Department of Cooperative Governance and Traditional Affairs to give greater guidance to local municipalities, specifically metro municipalities and provincial governments, to engage outside of a national framework, but obviously still within the national foreign policy agenda, to negotiate at lower sort of subnational levels agreements with other states. I think it's very important because, South Africa is not necessarily, I think, a federal country in the way in which Germany or the United States of America may be, but I do think that more power should be given to cities and provinces insofar as signing those agreements between other states, especially regarding trade, the development of economic infrastructure, for example. I know that the French government recently has committed to providing a loan of 100 million euro to reform local government service delivery, specifically in water, electricity, and economic infrastructure. And that money, I think mostly is sent to National Treasury because that is where it's seen to be most safe, because there aren't necessarily mechanisms to allow for that to go directly to municipalities or possibly to provincial governments in a way that it can be ring-fenced and properly utilized for the services that it's intended for. So my question is just, to what extent can subnational governments also engage in a treaty-making process to give greater legislative guidance and effect to international relations outside of not necessarily treaty-making, but agreements, so that those spheres of governments and branches of government rather are given greater effect, I think, outside of just DIRCO, and really decentralizing the approach to make it easier for international relations across South Africa. Thank you, Chair.
No, thank you very much, Honourable Smith. Honourable members, I believe that we were meant, okay, Comrade Chair, noted you.
Thank you very much, Honorable Kumbaka. I've just stopped on the side of the road here. I want to suggest that we must make a proposal to the Speaker that the Speaker tables to the Programming Committee a proposal that says, when these treaties are submitted through the presidency to Parliament, the Speaker must refer them to the relevant portfolio committee. In this instance, it's our committee. And that the portfolio committee must be given sufficient time to do consultation with the people of South Africa on the treaties. One, for the people of South Africa to understand the treaties. Two, what are the implications? How do these treaties impact on their lives? Three, how the people of South Africa can input in the processing and finalization of these treaties going forward. Linked to that, maybe our research can make a proposal and come back to the portfolio committee and indicate to us, can we categorize these treaties? Which means there will be treaties of a particular significance which will require a certain action or response from ourselves as a portfolio committee and parliament. So they categorize them, right? And then we can deal with them in that way, which means they will come back to us. We are not finalizing it here today. And as soon as that is researched, we will then include it in our bigger proposal to the speaker. But the other thing which is important, honorable members, and this one we don't need the speaker and parliament, is for us to have twice a year, is my view. Twice a year, we set aside at least 2 days where, as a portfolio committee, we are going to discuss with the department the extent of success in the implementation of these treaties. So it will be treaty by treaty, all of them. Then the departments must report on the progress we have made and the impact we are making through the treaties, so that we can interrogate that particular report. The last proposal I want to make is that the portfolio committee, through our researchers, we must identify an institution of higher learning that we must work with for them to do a snap research for us on whether the people of South Africa are aware of the treaties and the work that DERCO does on our behalf, and whether they've got an affinity to the work that is done by DERCO. And thirdly, what is it that they're suggesting based on empirical research that we can insert to improve the linkage between what DERCO does and the role that the people must play on the ground. I just wanted to make those 3 proposals, Chairperson, so that at least we can encapsulate the proposals that were made here. Which will include what Muruti has suggested, what the son of the First Nation has suggested, and what Honorable Smith has suggested. By and large, in the proposals that we need to make to the speaker for the intercategorization that the research is going to do, is also that proposal by Honorable Smith of devolution, because we've got the 3 spheres of government. For the research from our researchers to say what role must be played at which level of the spheres of government, and how do we bring in the Intergovernmental Framework Act, which is a consequence of the constitution that we have this year. The advantage we have is that our constitution is doing 30 years this year, and in May, according to the Constitution of the Republic and the rules, there is a committee established by Parliament to look at possible amendments to the Constitution. So this will help us as part of doing a 30-year review of the Constitution in the context of international relations. That as a committee, we can then suggest some amendments to the rules, to the Constitution itself, and to how the programming committee does its work. Thank you very much, Chair.
Thank you very much, Honorable Chairperson, for that input. Can we move to Honorable Douglas? I think your hand is up, or is it a legacy hand?
No, I just wanted to second the proposals formally on the platform so that it gets noted for minute purposes, and want to agree with the chairperson in his comments and on the proposals, and just to make sure that some of the suggestions that all of us have made is incorporated in that letter to the speaker. Thank you.
Thank you very much, Honourable Douglas. I believe we're all on par. Honourable Reverend Wish, just noted, just so you hand now.
Thank you, Acting Chair. In my language, we say "Kilaka leo," meaning I agree with seconding what the chairperson has said.
Thank you very much, Reverend. I think we agree on, well, most of us do agree with what Honourable Chair did propose, and I think it should be something we should monitor and implement as this portfolio committee and ensure that it does ensue. Before I move on, I think the matter on hand has already been comprehensively presented by the department, including the valuable inputs from our honourable members. And as such, there will be no need for the further presentation from Parliament on the matter, because we have devised a way forward for this matter as this portfolio committee. So we will not proceed with the presentation which we're going to get from Parliament. But now may we please proceed to the departmental inputs on all those matters which were presented by honourable members. Yes, I'll then move to the department for that. Thank you.
Yeah, hello, Chair. I'll seek obviously to deal with the approach of the treaties as it relates to our economic integration is concerned. And the member of our Foreign Service, Ms. Romy Brahma, who is the director in Oxlade, will, I think what she will have to do, obviously, is to speak about what is the constitutional provision as it relates to the separation of powers in terms of treaties that are obligated to go through a consultative processes with Parliament. That includes National Assembly and the ones also as it relates to the National Council of provinces, and also the relevant sections that detail the executive powers. I'm raising this, Chair, because there is a very important matter as we celebrate our constitution, that the South African state, of course, is a constitutional organ, and there is the doctrine of separation of powers, which specifically highlight the role as it relates to the judiciary, the role as it relates to the executive, and the legislative authority. So, in as far as the legislative authority is concerned, it encapsulates, of course, the power to make, amend, and repeal the rules of law, whereas the executive authority really speaks about the power to execute and enforce the rules of law. So I would want, obviously, the Ms. Brahma to speak about that, the specific constitutional sections, and just try to detail that. And thereafter, I will obviously want to make my intervention on the economic treaties as it relates, for example, to the economic advancement of our people, and how necessarily it's supposed to then benefit our national interest, and in particular mitigate on issues about unemployment, poverty, and inequality. So, having said that, Chair, if we can ask Ms. Brahma to do a contribution, and I'll then thereafter follow. Thank you.
Thank you, Tim. She may proceed.
Thank you very much, Honourable Member. So perhaps the way to introduce it is maybe just to give a little bit of a background as to what informed the distinction between Section 2312 and 2313. So the reason why they created these two different approaches to international treaties within South Africa under the Constitution was to balance efficiency and the need to ensure that South Africa is responsive to certain agreements and it doesn't get caught up in too long a process, whilst at the same time ensuring that there is the necessary oversight and checks and balances when it comes to really significant and substantive agreements. So Section 2313 is intended only for executive agreements. So these are agreements that would fall within the domain of a single department. So as soon as it starts to cross over and have implications that would be of serious concern for other departments, we would then look at it and classify it as a Section 2312. And it's in that one sort of ensures that there's this movement to allow South Africa to be responsive. I mean, the time that it takes to negotiate, sign, and for treaties to enter into force is really very long. And if one adds the parliamentary process, it could become detrimental in the functioning of government. So that was the reasons behind why there were these two different approaches that were implemented for Section 2312 and 2313. And as Deputy Minister Botha has mentioned, it also is a very critical aspect of our constitution and the principles on which our country is founded, that the separation of powers is incredibly important. So certain aspects, there is absolutely the need for parliamentary oversight, but there needs to be caution that that oversight doesn't necessarily result in an overstepping of that responsibility and moving into the sphere of the executive responsibility. So the Constitution is very clear. Section 2311 gives executive power to the signature and negotiation of treaties. So Parliament would not be consulted in the negotiation because under the Constitution, it is the executive's role to do so. When it comes to the more far-reaching agreements that have implications that will affect citizens and their rights and so forth, that's when we move into the realm of Section 2312, and that's where we would need Parliament's approval before that agreement can be bound. So whilst a signature may be appended, it will not become binding on the Republic until Parliament has approved it. And Parliament may, in its discussions in Parliament, make a recommendation as to changes that it would like to see, reservations that may not have been proposed that it would still nonetheless want. That falls within the powers of Parliament to do. And sort of at the extreme end of the spectrum, Parliament could say, we don't want to, we don't agree with proceeding with concluding the agreement. Perhaps just to answer a few specific questions about, I think Honourable Wesley Douglas had requested some information on statistics. We can certainly provide that. We would just need to engage our treaty section in order to obtain all of the specific details of agreements that have been signed and concluded in the last period since the GNU was established. And also then just perhaps to explain, when it comes to the classification of treaties, the way it works is that an agreement, after it has been negotiated, it is submitted to the Department of Justice for legal advice. During that process, the department carefully scrutinizes whether the agreement is compliant with South Africa's domestic law. And where there are problems, it will identify that there are provisions with which the agreement and the domestic law do not align. And then it would make a recommendation about or advise that if there are no problems with the domestic law, that the agreement may be signed, and it would classify the agreement as one being under Section 2312 or 2313 based on its analysis of the text of the agreement and the implications that it may have. After that, Justice's legal advice is submitted to our office, which is the legal section in DIRCO. We then scrutinize the agreement from an international law perspective to ensure that the treaty is compliant with all of South Africa's international law obligations and international law broadly. We will also look at it from a perspective of the legislation that we are supposed to sort of implement from our department side. So, for example, the Diplomatic Immunities and Privileges Act. And we will then make a further recommendation as to whether it's compliant with international law. And perhaps also just to mention, under international law, there is a provision in the Vienna Convention on the Law of Treaties which provides that if a treaty is or a state is not allowed to raise their internal law as a reason for non-compliance with their international obligations. On that basis, our office would, if the Department of Justice has raised concerns on a domestic level, we would then make the conclusion that we cannot sign it on an international level because our domestic law does not align with the international provisions. So once we've concluded that the agreement is in line with domestic law as well as international law, it can then proceed to the next phase of signature. And we also serve as the second classification point, where we would determine whether the agreement, the subject matter, the content is in line with what is envisaged under Section 2312 or Section 2313. So there is a legal oversight as well before the agreement proceeds to the phase of signature. Then just to answer a couple more questions. Apologies, I'm just looking through my notes to see the questions. So also just to mention on the process that we undertake in terms of the other spheres of government. So DIRCO does vet non-binding arrangements that the provinces or municipalities wish to sign with international counterparts. And under the Constitution, provinces and municipalities do not have the authority to conclude international agreements. This is purely an authority that rests with the executive, the national executive. And so, excuse me, when we look at those proposed arrangements, we ensure that non-binding language is utilized, so it allows for cooperation, but on a legally non-binding basis. And we propose amendments to the language to make sure that it remains non-binding, because other spheres of government cannot bind the country. It's not allowed for in the Constitution. The Constitution also sets out the scope of responsibilities of national government, local government, and the provinces. And so we would need to ensure that, and in fact that's the responsibility of all the spheres of government, to ensure that any negotiations for arrangements are in line with what they are constitutionally authorized to conduct. We try to have, we did in the past, and we're trying again to have roadshows where we engage the various spheres of government to explain the processes for concluding twinning arrangements and non-binding arrangements, and we hope to proceed with that as soon as we can. Then perhaps also just to mention that there is, I understand, a process in the presidency where efforts are being made to monitor the implementation of various international agreements. Unfortunately, from DIRCO's side, that would fall outside of our mandate. Our mandate is to record and to sort of serve as an information repository. We cannot look into the implementation, because that would be for each line function department to implement and carry out monitoring processes to make sure that what they have concluded is in fact being attended to. But there are also various means through which we try to do that, and that is the biannual reporting to Parliament or to Cabinet, where we ask for inputs from various departments as to the status of international agreements. And then I think that's perhaps it. I think perhaps just also to mention on the question related to the status of international law and non-compliance with international treaties. I think maybe just to mention that international law is often looked at through the lens of domestic law, and it's perceived as having a lack of enforcement capacity because there's no separate entity that ensures its enforcement. But there is enforcement. It's just we need to, I think, change our perspective a little bit, that the enforcement is a self-enforcing approach, and it's done through peer review. It's done through soft powers, and not necessarily in the same way that we would see it in domestic law. So although we are seeing challenges with international law, it's not to say that it isn't worth pursuing. It's not to say that it doesn't still make a difference. We've discussed it a lot within our office and internationally, and I think there's a general agreement that international law plays a critical role, continues to play a critical role, and must be utilized by countries like South Africa to promote the importance of complying with a rules-based system, particularly for countries that are not as powerful. It levels the playing field, gives an opportunity for countries that do not have the hard power to operate in a system where their vote carries equal weight. So I certainly think that we should continue to see how we as South Africa can promote international law. So thank you very much.
Thank you very much, Chair. Look, Chair, just from my side, there's a important article that I thought, in terms of the broader, that explains or seeks to further clarify the process of domestication of treaties and the implementation thereof. It's quite important. It's an article written by Erica de Wet, and I think subsequent to this meeting, I'll obviously would want to share it with the secretariat, of the PC. One, Chair, look, if we speak about what is the role of DIRCO as it relates to treaties, vice versa, responding to our national interests, and in particular broadly on our economic fortunes. You will recall, Chair, that a key multilateral organ which seeks to really provide stewardship around this very important matter that both members, Moshwe, Douglas, and Smith, have raised. And I think, Honorable Moela was quite comprehensive in terms of the constitutional issues, which we will, of course, seek to deepen through a formal communique. But if you look at the WTO, Chair, there has been, this is really one of the arms, or mechanism through which we seek to ensure there is we advance the promotion of trade and economic development through the WTO, given that one of the provisions, Chair, of the WTO seeks to, moderate the matter as it relates to the reduction of tariffs and other restrictions. And you will recall, Chair, that there was the general agreement on tariffs and trade. Secondly, you will also recall, that there was the African Continental Free Trade Agreement, which really seeks to bind all AU member states as it relates to the liberalization of a single market for our goods and services. So this, of course, was very key and critical to ensure that our economic diplomacy, as it relates to economic trade and intra-Africa trade, we are able, obviously, to provide a particular emphasis on that issue. And I think honourable members would be able to look at the figures released by DTIC. If you look at your figures as it relates to 2025 and contrast that, chairperson, before the operationalization of the ACFTA, I think members will appreciate that we have been able to leverage economic trade through the ACFTA. So this obviously it's a critical issue. So this is two of the treaties that broadly speak about economic development, and of course, Chair, we can detail any other treaty that for this administration for which the PC is responsible for that are under consideration, so that we ensure that there is some information that the portfolio committee have in relation to that matter. And I think the important issue, I think there was a matter raised by, I think it was Honorable Smith, in terms of international obligations, vice versa, international enforcement. Now, you will recall that really the only one organization that has the rights to enforce obligations as it relates to peace and security, that's the UNSC. If you look at the ICC, you look at even the ICJ, where certain members have decided, for example, Hungary of late, have refused to exercise its obligations in terms of the statute. And there is not necessarily enforcement obligation where you can then engage in a unilateral punitive measures against Hungary, because ultimately what members of the PC must appreciate, it's what we sought to suggest earlier on, that in essence your international treaty is part of what we call the collective mantra, the collective goodwill of member states of the UN in relation to the advancement of multilateralism and to build a just, equitable world order firmly premised and embodied in international law. So when certain countries, and by no way, Chair, should there be reference drawn of the initial action that the government or the executive at some stage took in relation to the Bashir matter, you would recall at that time there was an obligation to implement the ICC provisions, but the government of South Africa at that time sought a what we call judicial certainty in relation to what does the court demand of it. And once the court had been very unequivocal and clear that you can't have a domesticated legal process, or you can't even use your immunities and privileges as it relates to the Vienna Convention, not to enforce your ICC, indictment. We have been very clear as a government that we have a duty to, implement the full prescripts of the ICC statute. Countries like Hungary and all other countries where there was not a a flight restriction imposed on the movement, for example, of the Prime Minister of Israel, Benjamin Netanyahu, of rate of recently and in 2025. It's of course rather unfortunate, but we continue to engage within the collective body of the UN in relation to, the unfortunate malpractices that member states that has ratified the treaty are actually engaged with. So I think, Chair, that is where I would want to pause. And I know that I've asked the Director General to make an intervention. I know that he was chairing a particular internal process of the department. So if he is able to make an intervention, Chair, I thought I must maybe just ask him, especially as it relates to the outcomes, what the chairperson of the PCF requested, the outcomes of the 2026 G20 retreat of the African Union held in Equatorial Guinea, which in essence focus on the establishment of a strategic roadmap for Africa's engagement with the G20 under the 2026 US presidency, given the important issue, Chair, that there needs to be tangible developmental gains for the African Union in line with Agenda 2063. So, with your permission, Chair, if the Director General is able to do intervention, then of course I would maybe just to concretize what I've said on the retreat. If he's otherwise engaged, what we can do is also provide you with the written outcomes of how the AU Commission have perceived the outcomes to be in relation to the retreat. Thank you very much, Chair.
Thank you very much, Tim. I think we would definitely appreciate the written outcomes to be shared as soon as possible in the committee so that everyone is aware of what is taking place. But if he's not available, if he's not available for a 5-minute presentation now, it's fine. We can get, okay, I see. Before I give you DG, I've noted the hand of Reverend Meshwe, and then I'll give you the platform just for 5 minutes just to outline that. And then if there are any follow-ups, we'll take it from there.
Thank you for your indulgence, Acting Chair. When the official was responding to our questions on treaties, she referred to the second phase of signatures. Now, I want to know how many signatures are required before a treaty is enforceable, and what has to happen before the first signature is attached. So what I really mean is that they would want to know how many stages would be required before the final signature is given, because she spoke about the second phase of signatures. Thank you, Chairperson.
Thank you very much, Reverend. Before I give the department to answer, let me give the TG so that if there are TG,
Thank you very much.
Thank you.
Thank you very much, Chair. Good morning, honourable members, Deputy Minister, and thank you for giving me literally 5 minutes because I've have to go back in and chair the panel. Just on the retreat that took place in Equatorial Guinea, just to start off by saying that we will send a written report because we've got a good team that's participating there, including our own G20 team that's been working with the African Union. But the social media post that the African Union made that created a lot of unhappiness was not in keeping with the resolution by the heads of state at the African Union Summit that not only supported and endorsed South Africa's presidency, but raised serious objections to the exclusion of South Africa by the current president of the G20, which is not in line with the rules of the G20, irrespective of the fact that the G20 is an informal organization. There are certain accepted rules that permanent members are not subject to invitation. So this was precedent setting. The heads of state had directed the commissioner responsible for the G20, was also the Sherpa, to raise these objections at the upcoming Sherpa meeting in June. The initial objections was raised by the African Union together with most of the other Sherpas in the first meeting in December. So South Africa's exclusion is still on the agenda. It's unfortunate that the comms unit of the AU used the G20 logo of the US and even subordinated the AU's G20 logo in that process, and that gave the wrong impression. The meeting in Malabo follows on coordination between South Africa and the AU over the last few years, where we would coordinate positions that would advance developmental issues that are important for the African Union and African countries as a whole. And this particular meeting was more important given the fact that South Africa is not there. The South Africa not being there meant that the African coordination, where South Africa would work with the AU Sherpa and the representatives of the African Union to ensure that issues of developmental importance to the continent are emphasized. So we sent a significant team, both from our Sherpa team, but we've also got from sister departments from DTIC and others that are active in that meeting in Malabo. And it is about ensuring that whatever the status of the US summit is going to be, because part of the issues on the agenda is whether they can call the outcome a summit without South Africa's participation. And remember, our participation is not non-participation is not voluntary, as was the case with the US, was also a permanent member. We wanted to ensure that key issues are put on the agenda, even though they only have 5 working groups in the US this year, and there's only 10 meetings taking place in total, that African issues remain on the agenda. I think it's important to note that at this meeting, there was a close discussion with the Sherpa, our team, and also the representative of African states, where there was an agreement that, again, they will raise the concerns and objections about South Africa's non-participation based on an invitation that should not have taken place, a non-invitation route. That being said, we continue to be a full member of the G20, continue to work with the family of the G20, and this includes working with the next presidency quite closely, which is the UK, around areas of handover of issues that are not being dealt with in this year's presidency. But we will give a written report so that the details of the outcomes of the retreat can be shared with the portfolio committee. I'm sorry I can't stay much longer, Chair. Over to you.
No, thank you very much, DJ, for that presentation. If there's any other follow-ups, are there any other follow-ups in the platform so that I can move to the department to answer Reverend Mishra's question? Okay, I'll take it that there's no follow-ups on what the TG has presented. Committee, Honorable DM, may you please just allow us to get an answer for Reverend Mishra's question. Thank you.
Yes, no, absolutely. Ms. Stemmer, can you just do an intervention, Roman?
Thank you very much, Deputy Minister and Honourable Kumbaka. With regards to Reverend Meshwe's comment or question, just to clarify, there are two, and apologies for not being sufficiently clear. So for the Section 2313 process, the first step would be a signature of the international agreement, and that would be an executive act through Section 2311. And then following the Earth Life Africa case, we implemented a process internally within our own department to make sure that we don't have a replication of that situation whereby South Africa fails to, or a national department fails to table a Section 2313 agreement to Parliament for information purposes. So the process we've implemented as the second phase would be, after it's been a treaty has been tabled for information in Parliament, then there would be a notification that is sent through the diplomatic channels to the other party to the agreement, informing them that we've complied with our constitutional requirements and that the agreement can enter into force. Then in terms of Section 2312, normally the process is that there would be a double step, the first being a signature, and then the second step would be an instrument of ratification. So the first step, which again would be a Section 2311 Executive Act, which requires that the matter must be approved by Cabinet before the signature can be appended. That would be the first step, and what that effectively results in is that South Africa wouldn't be bound, but it doesn't get international rights and obligations from the signature. It is bound by sort of observing the spirit and objective or the object and purpose of the treaty, but there are no sort of enforceable obligations within the content of the treaty. The second step then would be that the international agreement would have to be tabled in Parliament for approval, and only after Parliament has approved it will the second step be embarked upon, which is the process of having the Minister of International Relations sign the instrument of ratification. Once that is then deposited with the depository of the agreement, South Africa would be bound to the agreement and the various provisions creating international rights and obligations. So those are for the two different types of treaties, the sort of double step or the two phases of being bound. I hope that assists. Thank you very much.
Thank you very much, Ms. Kumar, for that. And thank you very much once again also to yourself, DM, and your members from the department for the comprehensive presentations that you gave to us today, which I believe have been helpful and have guided a way forward for this committee on the matter of the treaty making process. I think it's very clear that the committee must get updates from the department on the latest biennial cabinet reports regarding outstanding reports to the treaty bodies. And the committee also notes the importance of strengthening record keeping and compliance monitoring across the government through DIRCO's treaty section. I think it's very important to establish grounds as this committee, how we can better support and work on this on our oversight on the treaty making processes. And I think the committee also raised some important matters that are important to ensure that the parliamentary committee has adequate resources to effectively analyze the developmental and legislative implications of some of the complex treaties. And I also think it's important that as a committee we highlight the need for improved early engagement between line departments and Parliament to reduce implementation gaps and strengthen South Africa's credibility as an international partner. But as a committee, it's very important for us to have that framework on how we establish this. With that being said, honourable members and colleagues, as we move to our closure and as we conclude this engagement on the process of treaties within the Portfolio Committee, I'd like to extend my sincere appreciation to all the members for their valuable inputs and thoughtful contributions And also in their contributions, you do it to emphasize your commitment to strengthening parliamentary oversight. The processing of treaties is not merely an administrative exercise, but it's really a constitutional responsibility that ensures international agreements entered into by our country are aligned with our national interests and our developmental priorities and democratic accountability. And our role as this committee remains critical in scrutinizing these agreements, ensuring transparency and safeguarding the interests of South Africans. And the quality of today's engagement reflects our collective dedication to this responsibility. I also wish to thank the department for the comprehensive and very insightful presentation, and also the inputs you gave to us when our honorable members articulated their views. And also to all our members from the department, and also our staff from the department, and also from Parliament. Thank you for all the work you continue doing. Your contributions continue to strengthen the work of Parliament and the department and reinforce our public confidence in our oversight role. Then lastly, before I close, I would just like to say, let us continue to approach our work with diligence, unity, and a shared commitment to advancing the interests of our people and our country. And with that being said, I then move to the adjournment of our meeting. And may you enjoy the rest of your Wednesday and the long weekend ahead. Thank you.
My apologies, Chair. We have a second presentation by Ms. Mosala. I'm not sure if you have mistakenly omitted that part.
No, I did mention before we gave the department the platform that we will not get the presentation from Parliament anymore, as it had already been comprehensively presented, even from the department, also with the inputs from the members of the committee.
Okay, noted, Chair. My apologies. Okay.
Thank you, comrades. The meeting is adjourned. Thank you, honorable members. Sorry.
Thank you, Chair. Thank you, colleagues.